Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Yesterday, I have seen a beautiful judgment delivered by Justice Sanjeev Khanna and Madam B.V. Nagaratna of the Honorable Supreme Court of India regarding Section 300 of the CRPC or regarding double jeopardy. You may be knowing, according to Article 20 of the Constitution of India, a person should not be vexed twice for the same offence. Even Section 300 says in the same fashion. Please remember, here the Supreme Court gave a clarification that the double jeopardy, Section 300, applies not only to the trial of the same person in the same type of case, but another case, it applies to another case basing on the same facts. Simply to say. So in the meantime, I will, while the video is going on, I will tell you the difference. But anyway, Honorable Supreme Court of in the case of T.G.Gopla versus State of Kerala, in Criminal Appeal number 187 by 88 of 2017. So 187 by 2000 maybe, okay, whatever it is, 187 by 88 of 2017. So Justice, I will tell the B.R. Gawai and Madam B.V. Nagaratna, they delivered the judgment that double jeopardy applies not only to the trial of the same offence twice, but also to the trial of any other case basing on the same facts. If you know the details of the case or facts of the case, then it is better to understand. So, the accuser, appellant, Mr. T.G.Gopla, he worked as the agriculture officer, State Seed Forum, Penumbra. So, Perambra, maybe in Tamil Nadu state, from 31/5/91 to 31/5/94. For 3 full years, he worked in the State Seed Forum, Perambra. Right? So there are allegations that he has misused the public office and he has committed breach of trust, he has tampered the records and he has misappropriated amounts from 27/4/92 TO2 25/8/92, almost for 4 months by not maintaining the records for the selling of the coconuts. So the allegations, the lower staff, they don't keep quiet, or the persons who are opposed to him, they don't keep quiet. Definitely in the government sector, you know, they will be sending a lot of petitions. Likewise, allegations were made against him. So inspection was conducted by the Vigilance and Anti-Corruption Bureau sleuths, and the department also conducted inquiry. So it was highlighted that, or the inquiry revealed that the cash book was not maintained properly. Right, and he has misappropriated the amounts. So basing on the report of the Vigilance and Anti-Corruption Bureau, a criminal case was registered against him under sections 409, that is misappropriation, 477A, forgery for the purpose of cheating, and section 30 and IPC, and section 13(1)(c) of the Prevention Corruption Act 1988. So he was there. In the meantime, please remember, an inquiry or a departmental inquiry was conducted by the audit department. They have also, the audit report clearly disclosed that he has not entered this thing, he has not shown it clearly, all these things. So another case of breach of trust was registered against him. So now 2 cases were registered against him. So therefore, he has approached the Honorable High Court. High Court stated no, because he had to, of course, High Court was a bit lenient towards him because of the submissions by Mr. Gopal Krishna stating that he was in charge of the Perambra, he has to depend on the subordinates, so he has to depend on the subordinate to conduct the affairs of the so-called Perambra. So, and that too, he is a public servant coming under the purview of section 197 CRPC. Therefore, sanction is necessary from the government to prosecute him. So anyway, the main contention is that basing on the same contents, The vigilance people as well as the audit department, they have given 2 reports and 2 cases have been registered. Now, the say of the government or the government pleader says that the criminal case is regarding his guilty mind, 409. So, misappropriation, the guilty intention, he has fraudulently defrauded the state to a tune of so and so. Whereas the audit is concerned, it's almost a civil matter. Almost, of course, it is only the accounts. So 477 or some section was there. So both of them are different as per the view of the government. But Supreme Court stated that even though you have to register 2 cases, one on the accounts and second on the fraud, both of them are on the same facts. Both of them are the same facts. You cannot say that both of them are separate. So just like, so therefore, ultimately, Supreme Court clearly stated that Section 409 has no locus standi or it has no legal basis because the doctrine of entrustment was not at all proved by these people. So definitely, it amounts to double jeopardy, which is against to Article 20 of the Constitution of India and Section 40 of the Indian Evidence Act and also Section 71 of the Indian Penal Code. Double jeopardy is mentioned in Section 26 of the General Process Act also. Anyway, both the cases are on the same set of facts, therefore, so it amounts to double jeopardy and therefore the second case. So, okay, you know what happens in double jeopardy. Only one case will be taken up. But there are certain circumstances where a case may be leading to 2 types of trial. For example, it happened. It is a practical case. So, in a case of 381 of the Indian Penal or 380 of the Indian Penal Code. So, some servant committed theft of a gold chain from the house. And he was working as a servant of the same house. The police inspector registered the case and he has sent him to the court. Fine. But when the DSP conducted the inspection, it came to light that the servant threatened the owner of the house due to and snatched the so-called gold chain, which amounts to robbery. So this 380 was converted into 394 IPC and the trial was conducted de novo, second inquiry. So will it be double jeopardy or not? So the matter went to the High Court of Andhra Pradesh. They said it's not double jeopardy because it is a section, appropriate section. Previously they have given luckily the trial could not conclude. That was not concluded. In the meantime only 394 was added. So therefore certain times you may be confused that basing on the same facts, the conversion of the case from 380 to 394 will be there. That is allowed. That's what I want to tell you. So likewise, in 324 cases, a person is injured, he has come to the house, ultimately he croaked, it will become 302. So even though he filed the charge sheet under section 324 IPC, if there is continuous treatment of the person, if he died while taking treatment, it will become 302. So it cannot be double jeopardy. So friends, please remember, double jeopardy means a person should not be vexed with the same offense 2 number of times. Maybe the same offense or any other offense basing on the same facts. So this is most important. So while we will deal with the term of res judicata, then you will be in CPC section 11, you will be definitely understanding this concept in a very elaborate manner. Till such time, let us say bye. Thank you very much.